Oh, no. I want to know why they put him out of the home. Because if you have parents who put a child out of the home who is doing his best, seeking employment, and I find it just strange that that's the only reason why they would put him out. So I want to know if that's the only reason why they put him out. Kicked out from where?
My household,
And who's in that household?
my mom, my little brother, and my stepfather.
So why did they want you out? Vision with your attorney, did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2024 CR 012811 for the offense of theft of a firearm on February 4th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
Judge, really quick, there were two,
There too.
yes, so there's the one, the theft firearm, and then there's cause number ending in 001217W. That's a family violence.
All right. And then we're also proceeding then on 2025 CR 001217W.
Okay, and
Just one moment. And that cause number, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Are you the same Dalen Newman who was placed on deferred adjudication in 2025 CR 001217W for the offense of assault, bodily injury, family household on February 4th, 2025 for a period of 1 year? Is that you?
Yes, Your Honor.
All right, state, you may proceed.
we will be proceeding on the same violation in each cause number, and that's violation of condition number 4. In Bexar County, Texas, the defendant Dalen Newman did then and there fail to report to the supervision officer as directed for the months of March, April, and May of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
State, do you waive the other?
The remaining.
No objection, Your Honor.
All right, in cause number 2025 CR 001217W, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. And in cause number 2024 CR 012811, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Be true.
Yes, court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, and just so the court is aware, this is the defendant's first MTR, and he was placed on deferred adjudication in each cause on February 4th of 2025. And so the agreement for the court's consideration is to deny the state's motion, continue the defendant, but alter and amend his conditions to include a TAP evaluation to be done in custody, weekly reporting for 60 days upon release, the moral recognition therapy course, and a 30-day jail sanction to run concurrent with the days that he's in custody awaiting the TAP evaluation.
All right.
That was our understanding, Your Honor.
All right, do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Dalen Newman.
Why are you not recording?
I was going down the wrong path. I was kicked out and I was homeless and I couldn't
Kicked
have
out from where?
my household,
And who's in that household?
my mom, my little brother, and my stepfather.
So why did they want you out?
Because I wasn't able to find a job in the time that I needed to.
Why were you not looking for a job?
I was looking, but I wasn't applied to or recognized in the time that I was needing to be recognized for work.
All right, so here's the thing, and you correct me if I'm wrong. Usually parents love their children, and if they're doing everything they can to find employment, normally they won't kick them out of the home. So what else was going on in the home?
There was nothing else going on in the home, Your Honor.
So you're telling me if your parents were to testify, they're going to say We just put him out because he didn't obtain employment, that he was doing his best. He was going out every day trying to find employment, but he just couldn't do it. So we kicked him out because no one would hire him. You're telling me that's what your parents are going to say?
Yes, Your Honor.
All right. Then let's have the parents testify to tell me what was going on in the household. I want to know. Because I find it very strange that parents would put somebody out, a child who's doing the best they can, going out, seeking employment, and then they will put them out because they're unable to find employment. So,
Yeah, I do not believe that his parents are present today to testify.
oh, I mean, we can always recall this back. We can recall this back for Thursday. And if there's no objection, his parents can appear by Zoom.
Yeah, I believe that Mr. Newman has relayed to me. I believe that his parents are going to allow him back into the home.
Oh, no. I want to know why they put him out of the home. Because if you have parents who put a child out of the home who is doing his best, seeking employment, and I find it just strange that that's the only reason why they would put him out. So I want to know if that's the only reason why they put him out.
Understood, Your Honor.
And they'll be placed under oath if they appear. And then the court will hear that. So we can recall it for Thursday for your parents to appear. So that they can tell me under oath why they put you out of the home.
May I have a brief sidebar with my client, Judge?
Sure.
Before we proceed.
And who's the attorney for Jeremy Lopez and Isidro Garcia? All right. And counsel?
Yeah, may we reproach?
Yes.
After conferring with my client, Judge, he expressed to me that part of the reasons that he was not allowed in the home anymore.
Well, I mean, I want to hear from him
Okay,
because he's told me the only reason why his parents put him out of the home is because he was looking for employment and he couldn't find employment. I just find that hard to believe that a parent would do that if somebody is doing what they're supposed to be.
Mr. Newman, do you want to explain to the court what you just expressed to me?
Yes, sir. I said that I wasn't meeting their obligation, as in finding a job in time, as I failed to meet y'all's obligation in the 30 days.
What else did you tell me about probation?
Probation, that they said that I was failing to attempt to pursue my probation, as in checking in.
Well, no, I mean, you're still saying the same thing. You're adding, but you're still saying the same thing. You're saying that the only reason your parents kicked you out of your home with them is because you could not find employment. That's what you're telling me. That's what I'm hearing. If I'm hearing something different, let me know.
You're not.
All right, so you can have the parents here by Zoom and the reason why I'm doing this is because maybe that's not the right placement for you to be at home with his parents if they're putting him out because he can't find employment and he's doing everything else perfectly. So they can appear by Zoom.
All right, Judge, I just do not have any contact information for his parents.
Oh,
I will talk to Mr. Newman.
all right.
See if I can get them available. However, I do understand as well that in the court summary, it did state that the parents were, I don't know if they were available to be contacted.
Okay. All right. Well, he should have their contact information to see if he's been living with them.
The judge didn't raise her voice, but the pressure was heavy. A young man on probation admitted he stopped reporting. His excuse? He said his parents kicked him out because he couldn't find a job. The judge wasn't convinced. Parents don't usually throw out a child who's truly trying, she said, then demanded the truth. Now the parents are being called under oath to explain what really happened at home. Was this bad luck? Or accountability finally catching up? What do you think the judge will uncover? Comment below, and like, share, and follow for more real
All
courtroom
discovery,
moments.
did you review it with your client?
Yes, Your Honor.
Court will find that state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a building, that's state jail felony, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you enter agreement will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counselor, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
Mm, um,
So anyway, you have a plea bargain agreement with the state. Do you understand that?
yes, ma'am.
Outside of that agreement that you've reached with the state, has anyone promised you anything else?
No, ma'am.
All right. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 198 days in the Bear County Jail under 1244. There's a $1,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge, I believe the intention for the state was for it to be a judgment sentence.
All right, state, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting no contact with city, community, church. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? Guilty, not guilty, or no contest?
Guilty.
We had discussed no contest.
No contest.
All right, do you understand what a no contest plea means?
Yes, ma'am.
All right, state any evidence to support the plea?
State offer states one in attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. It's 1 and attachments. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We'd ask the court to follow the agreement.
All right, why are you doing this? How old are you?
I'm 23.
All right, according to the police reports, you're causing disturbance at your parents' home and you're committing burglary of a building at this church. Why are you doing this?
So I go to that church at night because it's an amphitheater church and I just like to walk the stage and listen to music. That's what I usually do. I go there to free my mind at night. And it just so happened that the time that I needed to use the restroom, I saw that there was a door open. And I didn't plan anything. I just was just curious why the door was open. And it's just something that I know I made a mistake.
Well, I mean, you made choices that were not good choices.
Yes, that's right. But I was really just curious. I did not plan anything like that. And it's just something that I ended up walking into.
And then they said that there was money missing. They said there was money missing after you had walked into the church and left. So it's more than just walking and being curious. You understand?
I believe that's the mistake there.
Well, I mean, did you take money or not? Because they're saying that you walked in, there was money before you walked in, and when you left, money was missing.
Yeah,
$619.50 was reported missing from the church cafeteria. How far did you go in school?
I made it to the last month of my senior year. It
Why?
was a school in the country of North Dakota, in the very country there. It was a school where there's only 10 kids in my class.
Mhm.
And the same 10 kids attend that same school from preschool to their senior year. And so when I went back to my senior year there, they were really judgmental of me. My parents are part of the military, so I lived in a lot of different,
Well, let me ask you this, because there are a lot of people who have parents who are in the military. Your mom said that you have been causing disturbance at the home.
and I could tell you that my family that I've explained to that the way that my mom is being, they could say that a lot different of a story than what she's trying to.
Well, you're 23, you need to get a place of your own
That's
instead of
because,
living with your mom.
My bad for interrupting. I was 19 when I first got incarcerated. And I was recently released a few months ago. So that's the reason why I'm 23 and still there now, because I was 19 before I was incarcerated.
And what's with this teardrop?
It's for a lot of things. It's not anything bad.
What is it for?
I feel like I've been put into a lot of positions where I've been forced to burn a lot of bridges that I've had. And because of that, I've lost a lot of people in my life.
So here's the thing. I really don't have a problem with tattoos. People can do whatever they want to, but teardrops beneath the eye have certain connotations. I don't know why people start tattooing their face. If you want to tattoo your face, fine, but your job prospects are going to be limited. And it's going to be limited to maybe being an actor, maybe investing in concealer, maybe working with a band, or maybe who knows, there'll be some great person who will see past the tattoos. So what is his criminal history?
I believe he's currently on felony probation in another county, Judge.
All right, and what are you on felony probation for?
And aggravated robbery.
Ah, thank you. Now I know what's going on. This is why I ask these questions. So the court is finding him guilty. The court is going to sentence him to 198 days in the Bexar County Jail under 1244. Give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. There's to be no contact and restitution, if any, to city, community, church. And the court will show that this judgment is satisfied so that the other county can come pick you up. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You better do better. Otherwise, you're going to end up the rest of your life in somebody's prison. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you. 2025 CR 0000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed, is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they're able to accept her and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're gonna see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee-high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS, she's been compliant, she's been enrolling programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off, she's not fled, she's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for a very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, sure.
All right.
Judge, on the second-degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision and deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's, the state is opposed, but there is an application for deferred on that case.
So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession of the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yes, sure.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settles, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count one or
Let me see. They're proceeding.
Okay.
They're proceeding on count two as a repeater. I'm sorry, wait a minute. They're proceeding on count one. They're waiving count two in the repeater.
Judge,
Yes.
here's that docket back and we initialed the plea bargain change.
All right, thank you, Hunter. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, are you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please? No contact, did you say no harmful or injurious?
No harmful or injurious contact with PECK, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240. And referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well, Phil visit.
Oh, thank you so much. Field visits one time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. you say you have a new child, your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself two questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you, Judge.
It's always great to see.
This was one of the hardest decisions the judge faced. On paper, Elizabeth Settle should have gone straight to prison, multiple felonies, past failures, and broken trust. But the court paused. She had a child. She showed real change. The judge didn't excuse her past, but asked a harder question. Is prison the answer? Or accountability with structure? In a final warning, the judge offered a choice: prison now or strict probation with drug court, GPS, parenting classes, and the full threat of 20 years if she fails again. One wrong move and it's over. Did the judge show mercy or give one last test? What would you have decided? Comment below and like, share, and follow for more real courtroom moments.